Respondent did not respond to the order to show cause. Instead, he sent a mailing to the Office of Disciplinary Counsel. In that mailing, he enclosed a number of copies of a color image of Flavor Flav. What?
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
So in today's news, we're about to cover a story that I can best characterize as an example of what not to do. If you've ever wondered, as I do, like, is there a situation where I would give up my law license? And I usually think about this in the context of keeping my law license, not in the context of, how much money or what situation could I trade my law license for? No. That's not usually the way I think about it. So in this next story, it's a little bit strange that the attorney involved wanted the disbarment or the termination of his law license as a trophy. This is the matter of Glenn Stevens III, who is a suspended member of the bar of the District of Columbia Court of Appeals. In this extraordinary matter, disciplinary counsel seeks to have respondent disbarred. Respondent also unequivocally and colorfully has sought to be disbarred. In this unique posture, we must determine whether the disciplinary system should expend substantial resources on the merits of a case that each party would like to have end in disbarment. For the reasons set out below, we conclude that respondent should be disbarred without an analysis of the merits of his case. Without an analysis of the merits of his case, and we recommend that the Court of Appeals grant respondent's clear request that he be disbarred. This matter involves 4 separate disciplinary complaints against respondent. The court suspended him for failure to respond to a board order where disciplinary counsel's investigation involves an allegation of serious misconduct. Respondent did not file a response there. Does it say what the conduct was? Not there. Okay. Respondent was personally served with the specification of charges on April 11th, 2017, but did not participate in any hearings before the hearing committee, either in person or through counsel. He did not file an answer, nor did he file any other pre-hearing documents. He did not appear at the hearing, nor did respondent file a post-hearing brief with the hearing committee. Rather than participate in these proceedings on March 1st, 2018, which was the deadline for the exchange of proposed hearing exhibits, respondent sent an email to disciplinary counsel. The email subject was, "Maybe I wasn't clear," and its content requested that disciplinary counsel disbar respondent. He said, and I quote, "Please don't kill trees, waste taxpayer resources and ODC personnel on me. ODC has no credibility or legitimacy to me, or the drivel you generate. You are simply dishonest lawyers who do nothing to regulate dishonest lawyers, and racists to boot. Rather than wasting time, money, and paper on your sophistries, please disbar me. Disbarment by ODC would be an honor. To date, aside from competing in the Triathlon World Championships, my greatest honors are my Ph.D. from UCLA and my law degree from Boalt." I don't even know what that is. "But a disbarment letter from ODC will be framed and go up right alongside those diplomas. Please do me the honor of disbarring me. I will be so very, very proud. Signed, Glenn." Really? Does that sound contemptuous to you? That sounds contemptuous to me. Do you think maybe someone was just fed up with their law practice and sent off a contemptuous letter? I'm trying to be polite here. After disciplinary counsel put on evidence at a 4-day hearing, an ad hoc hearing committee painstakingly analyzed each of the allegations against respondent and issued a 252-page report concluding that, in representing himself and various clients in litigation and related proceedings, respondent abused the judicial system and ignored the ethical boundaries of adversarial advocacy that are key components of that system. The committee determined that respondent violated rules about frivolous claims in 4 matters, expediting litigation in 1 matter, violating the rules of a court or tribunal in 1 matter, communicating with a represented person in 1 matter, embarrassing or burdening third parties in 4 matters, serious interference with the administration of justice in 3 matters, and misuse of criminal/disciplinary charges in 2 matters. The hearing committee recommended that respondent be suspended for 3 years with fitness, which I think means that they want a fitness and character re-examination before the person can be reinstated as an attorney. Disciplinary counsel takes exception only to the recommendation that respondent be suspended for 3 years, arguing instead that he should be disbarred. Respondent has not taken exception to the hearing committee report or the hearing committee's recommendation. Respondent's email to disciplinary counsel indicated his desire to be disbarred. However, once a disciplinary investigation has begun, respondent cannot simply turn in his law license back to the Court of Appeals. Quoting the law, under DC Bar Rule 2, Section 7, an attorney may not avoid imminent disciplinary review by filing a voluntary resignation on the eve of the commencement of a disciplinary proceeding or investigation. Instead, the rule sets forth the conditions which a respondent may consent to disbarment while an investigation is pending or after formal charges have been filed, which requires consent. The consent requires the respondent submit an affidavit that consent is freely and voluntarily rendered, that the attorney is aware of the current allegations, that the attorney acknowledges that the material facts upon which the allegations are predicated are true, that the attorney submits the consent because the attorney knows that if the proceedings were brought, the attorney could not successfully defend. Upon the filing of a conforming affidavit, so conforming means properly filled out, has all those things, has those elements, right? Has to have those elements in order to be valid. The board would then recommend that the court disbar the respondent on consent. Because respondent's email indicated his desire to be disbarred, but did not meet the requirements for consent disbarment set out in Section 12 of Rule 9, Rule 11, DC Bar Rule 11, Section 12. On July 17th, 2019, we issued a show cause order that set out the conditions under which respondent may consent to disbarment, including the statements that must be contained in the required affidavit. A show cause order is kind of a little bit backwards. Instead of him having to file the proper affidavit, they're saying we recognize that he's sent in this please disbar me letter, this very contemptuous please disbar me letter. And so the judge is asking for the parties to show cause, to show good cause, why they shouldn't take that letter to mean, this is essentially my affidavit. Might as well just hear me out on it and agree that I'm not going to participate any further. So they ordered that no later than August 1st, 2019, respondent shall show cause why the board should not recommend to the Court of Appeals that respondent be disbarred forthwith, based on his consent to be disbarred without further consideration of the proceedings against him. Disciplinary counsel responded to the order to show cause, arguing that respondent should be disbarred on the merits and not on the basis of his email alone. Disciplinary counsel argues that the hearing committee's findings, which respondent has not opposed, should be presented to the court as a further basis for disbarment. Disciplinary counsel makes 2 additional arguments against disbarring respondent on the basis of the statements in his email alone. First, Disciplinary counsel argues that the misconduct found by the hearing committee will be considered unadjudicated misconduct under Board Rule 9.8 if respondent seeks reinstatement in the future. So maybe the misconduct can't be reviewed under the same standard in the future. Second, the court's disbarment order might not be sufficient for the imposition of reciprocal discipline against respondent in the United States Court of Appeals for the District of Columbia and United States District Court for the District of Columbia. So normally when you get disbarred, you must send that disbarment order to other states for other states that you have licenses in to review. So I'm admitted in Pennsylvania and I have various admissions in federal courts. I would have to check my rules, but my understanding is that if I was disbarred in Pennsylvania, I have to send that disbarment around to the other federal courts and let them know that I've been disbarred so that they can consider disbarring me as well or kicking me out of terminating my admission to their court, which is what would likely happen. Here, if the Court of Appeals disbarment is not reciprocal, maybe there's little to no reporting requirement or little to no consequence of this attorney losing his admission to the Court of Appeals. We'll continue reading. Respondent did not respond to the order to show cause. Instead, he sent a mailing to the Office of Disciplinary Counsel. In that mailing, he enclosed a number of copies of a color image of Flavor Flav. What? From the hip-hop group Public Enemy, with the text, ODC is a joke, in all caps at the top of the page in what one can only assume was a reference to Public Enemy's 1999 song, 911 is a joke. What? I mean, we're getting a laugh out of it, but like giving up your law license, at least in this district, for a laugh is we're laughing at you, basically. Respondent also reiterated his prior allegation that members of the Office of Disciplinary Counsel are unethical and racist. The board is required to review the hearing committee record and prepare a report of its findings and a recommendation, which is then filed with the court. Our review of the hearing committee's consideration of each of the alleged rule violations would no doubt be a lengthy process given the extent of the misconduct found by the hearing committee. The board takes seriously its obligation to review hearing committee reports and is no stranger to the thorough review of lengthy records, even those in cases in which the respondent did not participate. However, the facts of this case are wholly unique and our rules do not contemplate the situation presented by these facts. Respondent has indicated his intent to be disbarred. To be sure, he enjoys a number of procedural protections by virtue of the rules. When this board issued the show cause order, we gave respondent the opportunity to avail himself of those procedural protections. Instead, he chose to ignore our order and mailed in a photo of Flavor Flav. I'm having a hard time with that one. We share respondent's concern about spending resources on a case where both respondent and disciplinary counsel want the same thing, respondent's disbarment. Where a respondent has indicated that he does not want the protections provided by the rules, these protections they're talking about are a hearing, a meaningful adjudication, an opportunity to present evidence, basically due process. Where a respondent has indicated he does not want the protection provided by these rules, we see nothing to be gained by an exhaustive march through those procedures. Accordingly, in light of respondent's unambiguous expression that he seeks to be disbarred and his response to the show cause order, we conclude that his response is the functional equivalent to meeting the requirements of the rules. There is no evidence that respondent's email was a rash, unthinking act. Charges were pending against respondent for approximately 11 months before he requested to be disbarred. He has not repudiated his request, even though disciplinary counsel used it to support its arguments before the hearing committee and the board in support of disbarment. He did not repudiate it when ordered to show cause why he should not be disbarred on consent. In short, nothing in the record suggests that respondent's disbarment request was unknowingly or improvidently made, or that he has thought better of it and would like to remain a member of the bar. We recognize the severity of this recommendation. However, respondent has clearly and unequivocally requested his own disbarment and has not withdrawn that request despite several opportunities to do so, and we consider that the additional time and effort for the board to review the 252 pages of factual findings and legal conclusions of the hearing committee report in this case will certainly delay the resolution of other disciplinary matters. Cue up lawyer Barry, what's his face from Arrested Development, saying that it's just too long to read. We didn't read it; it's too long. As he's in court in front of the judge and receiving the federal government's plea deal, and they just didn't read it because it was just too long. We therefore see no point in further diverting the disciplinary system's resources away from cases involving respondents who desire to retain their privilege to practice law in the district, or from the public that awaits resolution of contested proceedings. So basically, let's not waste further time with this person. Even though it seeks the same result as respondent, disciplinary counsel argues that the result should be reached through a different route: the creation of a waiver doctrine that would then be applied to respondents' conduct. Disciplinary counsel argues that our approach in the show cause order and this recommendation is flawed. Respondents' action should not be seen as the equivalent of meeting the requirements. Disciplinary counsel identifies potential undesirable consequences from recommending that respondent be disbarred without a finding on the merits. As a general matter, because each of the consequences would be present if respondent had consented to disbarment by following the literal requirements, we conclude that accepting these consequences is acceptable and consistent with the rules that govern our disciplinary system. We address the disciplinary counsel's arguments below. Let's see, on waiver, disciplinary counsel argues that we should use respondent's cause as a vehicle to create a new doctrine that would allow us to conclude that a respondent has waived arguments. So basically, since he didn't follow the form of signing the thing and consenting and that he understands and all that this would create an opportunity for him to weasel out of something later on. The consequences wouldn't be as great. So if we were to create said vehicle and adopt the hearing committee's report without substantive review, the board is sympathetic to this argument. Limiting the board's substantive review of hearing committee matters to those where one or both parties note exceptions would reduce the amount of time. However, the Court of Appeals has not adopted such a waiver doctrine of this kind, and we do not think it consistent with the rules to do so here. And lower courts will often not want to create new laws or new procedures until an appeals court tells them otherwise. There's no exceptions in the rules for how the board can do this. The board is not given any discretion, etc. Using this case as a vehicle would be a bold expansion of the law. Again, they don't want to create new law at the district court level or at the disciplinary council, in this case, letter. Unadjudicated misconduct. The disciplinary council argues that unless the board fully creates a record and fully consider the findings, there will be some misconduct that has been unadjudicated. Again, respondent could simply acknowledge any one of the disciplinary charges against him in an affidavit consenting to disbarment, and disciplinary counsel would be in the same position. Treating respondent's conduct in this unique case as satisfying the requirements for consent disbarment does not put disciplinary counsel in a meaningfully worse position with unadjudicated conduct than consent disbarment would. Reciprocal discipline. Disciplinary counsel notes, and this is my concern, it's concern that disbarring respondent based solely on statements in his email without any admission or finding of wrongdoing could prevent the imposition of reciprocal discipline in the D.C. Circuit and D.C. Federal District Court. Disciplinary counsel cites no authority to support this concern, and in any event, undertaking an extensive review of the alleged misconduct here for the sole purpose of possibly facilitating reciprocal discipline in another court is not sufficient cause to divert the board's and court's resources and contribute to the delay of other cases in the disciplinary system. So that they're saying that they don't necessarily care that he might not automatically be disbarred from other reciprocal admissions or other reciprocal bars or court systems, because that they're not going to expend their resources to pursue somebody who is in that situation, which is interesting. But he will have reporting requirements and likely have to report this on other bar admissions, and they'll consider whether they want to disbar him based on this misconduct. So they conclude that respondent has not even attempted to show cause why he should not be disbarred on consent, and that disciplinary counsel has failed to show cause why respondent should not be disbarred on consent. And so they recommend the court enter an order disbarring respondent on consent forthwith and without further consideration of the evidence in this case. Please, 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 they say, don't make us read the 252 pages. Well, there's a dissent. The dissent cannot agree with the majority's conclusion that respondent should be disbarred because the requirements for consent to disbarment have not been satisfied and the rules do not allow the board discretion to infer consent from circumstances such as those presented here. So the dissent's saying that you still can't do this. The dissent's lost. I mean, it's just the dissent. The majority describes the procedure to be followed when a lawyer under disciplinary investigation decides to consent. Because respondent has not followed that procedure, we conclude the board must carry out its duty to review the findings and recommendations of the hearing committees submitted to the board and prepare and forward its own findings and recommendations to the court. The majority has chosen not to review the 252 pages and because the respondent emailed disciplinary counsel asking to be disbarred and failed to respond to the board's order to show cause why he should not be. The majority candidly acknowledges that the respondent has not complied with the law to consent. Notably, the deficiencies are not technical or trivial. Most importantly, respondent has not submitted an affidavit declaring his consent to be disbarred, which is required. Even if respondent's email were construed as an affidavit, which it is not, its content only partially satisfies the requirements of the rule. Respondent's email asserts that he wants to be disbarred, and given the clarity of the statement and his failure to recant, we can safely find that he made these statements freely and voluntarily and not as a result of coercion or duress, two of the items that must be included in a consent to disbarment affidavit. Because respondent sent the email at issue in conjunction with the pending matter, we can also find that respondent is aware there is a proceeding involving allegations he engaged in misconduct, thus satisfying another part of the rule. However, the email does not satisfy the remainder of the rule. Nothing in the record permits a finding that that respondent is fully aware of the implication of consenting to disbarment. Similarly, we cannot find that respondent is aware of the nature of the proceedings pending against him. Respondent has not acknowledged that the material facts upon which the allegations of misconduct are predicated are true, or that he is consenting to disbarment because he knows that he could not successfully defend against the alleged misconduct. All of these missing facts are required components of an affidavit filed in support of a lawyer's request to be disbarred. Respondent's email and his failure to respond to the board's show cause order are inexplicable. However, they do not provide a sufficient basis for the board to avoid our duty to review the findings and recommendations of the hearing committee. That such a review may be arduous, an undertaking. Given the voluminous case record, it is not a reason for the board to avoid its obligation under Rule 11. For the reasons stated above, we dissent. And that's two of the board members dissent. Sergeant Bernadette, Ms. Sargent, and Ms. Cassidy. So super interesting. What would you give up your law license for? Not that. I wouldn't give it up for that, definitely. I would fight hard to keep it if I don't even know what the guy was accused of. We saw the list of things that he was, the enumerated list of categories of things he was accused of. But I don't think we actually saw the list. It was, by the way, frivolous claims in four matters, expediting litigation, so that would be not expediting litigation, violating court rules, communicating with a person represented by an attorney. You can't do that. You got to communicate through the attorney. Embarrassing or burdening third parties, so probably revealing information that shouldn't have been revealed. Serious interference with the administration of justice, misuse of criminal or disciplinary charges in two matters.
The complaint is that he didn't follow procedures and that he wasn't playing fair with opposing counsel and with the other people that he was in litigation with. And then he has a disciplinary investigation, and now he's not playing fair with them, and he's not following procedures with them. And the disciplinary counsel is sitting there being like, well, we think we can disbar him, but he didn't do the paperwork properly. Like, do we have authority to disbar someone if they don't complete the proper forms?
Even if they don't fill out the form properly.
I love that 2 members of the board are like, that's not how any of this works. Like, they're like, no, this isn't how this works. We can't do this. And the other ones are like, I mean, he asked for it.
But it's almost like the dissenters are saying, like, no, we're not going to give him what he wants unless he asks in the way that we have outlined. So it's almost like this, in my mind, a little bit petulant, like, no, if he's not going to play by the rules, he doesn't get the outcome that he wants, and we should adjudicate the way that we normally do.
I'm reminded of this quote, which Brainy quote says is from Bill Vaughan. A real patriot is the fellow who gets a parking ticket and rejoices that the system works. I would think you would probably always regret this later on. Like so let's be fair here. We don't know what's going on in the person's life, and this isn't a giant laugh at Glenn Stevens party. It's a little bit of that. It's not supposed to. That's not supposed to be the point. The point is to learn something from it. It's and I'm not. Like, I don't have an audience of 10,000 lawyers who are watching this going, yes, I'm going to remember. Some of you are lawyers. Some of you are involved in the law. And it's good to know what these standards are for those people, definitely. But on the larger note for everyone, the lesson to be learned from these things is eat crow while the crow is young and tender, or surely you will eat it when it's old and tough. This could have been taken care of. They only recommended a 3-year suspension. And he could have just simply dealt with that. He could have even fought it a little bit and probably got less than a 3-year suspension. Maybe if he was cooperative, they would have agreed to a 3-year suspended suspension, which is when you don't get suspended unless you screw up again, and then they'll reimpose the original 3-year suspension, and then whatever you get for the new violation as well. So it's like an extra incentive to keep your nose clean, and if you do, then they don't impose the punishment. So he probably could have gotten something like that, but he just didn't choose to participate for one reason or another. And the one committee already had to create a 252-page report, and the other committee is like, do I really have to read this? No, you don't. No, you don't, is what the answer was. All right, so that is our show, everyone. Thank you for joining me. I am Leonard French, your favorite copyright attorney. Thank you for all of our supporters in the month of October. We just did a great live stream with Joshua Davis from TandaPay yesterday. Go and find it on our channel, or we'll try to put a bubble in the corner for you here. Joshua Davis has sponsored our channel for the month of October again, and we were going to be making a video or two more about TandaPay. Last night's stream was pretty good. We look forward to your comments, your questions, and trying to identify the opportunities and the weaknesses in the TandaPay model. So check that out if you're interested. Also, thank you to our $50 plus supporters, Joe Tyson, Aspernari, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Snorre Wisotzky, blackleaf, and Benjamin Hitov, or Hitov. Apologize for mispronouncing your name, Benjamin, let me know. And thank you to the $5 plus supporters that are scrolling on the LED panel behind me and will be in front of my face here on the crawl. Yes, we are still doing a stream on Wednesdays, although it doesn't always happen on Wednesdays. This week it happened on Thursday because I wasn't feeling so well on Wednesday. The Wednesday stream is kind of flexible, but welcome Brandon, who is now editing for us on a more full-time dedicated basis. So hopefully we'll be able to put out not just more videos, but higher quality videos. I have a green screen to play with, so this is fun, trying to bring these things to you here with then like Leonard's cutout thing. It looks a little more professional. So things are slowly improving. So thank you for all of your support on patreon.com/ljfrench and sponsors.com/law. Without your support, this wouldn't be possible. I really appreciate it. So that's what we'll leave you with today. I will see you in the videos that drop. Love you all. Have a great weekend, great week, and I'll see you next time. Bye.